go into that one any deeper. I mean, that might be a topic for a whole separate discussion. I'm sure we could easily fill an hour on that. I have some questions for clarification, and I don't want to dominate the discussion or Q&A, but if there's an appropriate point to ask.
Yeah, no, we're in the Q&A.
Yeah, all right. Go for it. Well, the first one is just to clarify that. So in your chapters 1 through 4 here, you make two arguments, basically two substantive arguments. One is about the distinction between whether what matters is ownership and what matters is the contractual relationships. This first one, the distinction between ownership and the contractual relationships, that's just a conceptual clarification that anybody on any place in the spectrum should be able to agree on if they understand it.
Yeah,
right? I mean, you could easily imagine somebody defending the status quo, corporations owned by stockholders that have managed large numbers of employees with conventional employment contracts, saying, yes, we agree with what you're saying, that what really matters isn't that we own the corporation owns the buildings. What matters is that we employ a large number of employees. And that's what makes us the firm and what gives us the right to the
So it's like
the whole product.
If you're going to attack slavery, you don't attack private ownership of a cotton farm. You attack the slave relationship, the master-slave relationship. And it's the same here, that the ownership of buildings or assets, either directly or indirectly through a corporation, isn't the problem. The problem is the renting of the human beings that actually use those assets. Just as in the other case, it was the renting or the buying, long-term renting of the slaves. And by the way, of course, the normative distinction about slavery is usually drawn, well, it's involuntary, and in which case the answer is, well, suppose it were voluntary. And voluntary slavery was outlawed as well. And yet the difference between the voluntary slavery contract and the contract that's the basis of our whole economy is only the tenure, only the time involved. That whether you buy the labor, by the day or by the month or by the year or by the working lifetime is the only difference. And so it's on a continuum there. And that's, if you get into arguing with libertarians, that's a very interesting point, is because libertarians are at least consistent on this, some of them, that yes, you should allow people to rent themselves out, and you should allow people to, sell all their labor all at once. And in other words, Robert Nozick, the late and great philosopher of Harvard, said explicitly, yeah, we should allow people to sell themselves into slavery, and he's consistent. I mean, it's a bad theory, because labor is not alienable for 10 minutes, not to mention a lifetime. But if you're going to say, I see nothing wrong with the renting of people, then you should, in consistency, say, I see nothing wrong with the lifetime renting of people. And that's the slavery system in a voluntary form.
Okay.
That's another topic. We can. I wrote about that in the later chapters of the book, in fact.
My next question is, so the second argument you make is about the employment contract. And this was a question where a question for clarification, where I'm not sure what your answer is going to be. The first one I just wanted to clarify. The second one, it's not clear to me whether you're saying that the employment contract as we know it today, the conventional employment contract, is invalid, that that employees at companies and their employers are entering into contracts that are or should be considered null and void, or whether you're saying that the employment contract as we know it is unjust or less just than could be achieved if labor, rather than allowing itself to be employed, would form a firm of its own and take on the role of the firm in a more cooperative fashion.
I think you pretty much answered your own question. That they boil down to the same thing. That if you say there's something inherently wrong with the contract, then it's invalid. It's in terms of your sort of standard legal reasoning, you could say that the problem is impossibility, and it's it's uh, it's like the hired criminal that goes to judge said, I gave up, I transferred my labor, I wasn't doing it, I gave control of my labor to the employer, he employed me to commit the murder, to rob the bank, or whatever it was, and the judge would say, you didn't do that, and it's impossible to transfer a responsible agency. And if it's impossible to transfer responsible agency, then how can the contract be invalid? How can the contract be valid? And if it can't be transferred, so yes, it is an argument that the contract is invalid, and so it's not a argument that the contract is exploitative or that it's underpaid or something like that. And let's look at some of the other contracts that are abolished. The slavery contract's abolished. If you tried to sell your citizenship rights in the United States or your voting rights in Boston or wherever you live, that would not be considered a valid contract. And the old form of the marriage contract, the coverture marriage contract, where the woman gave up her separate legal personality in favor of the husband and was transferred from the cover of the father to the cover of the husband. And the legal slogan was a husband and wife are one person in law, and that one person is the husband. So the woman, in effect, gives up her separate individual legal personality. All those contracts are invalid. And so the idea of a voluntary contract, which people obviously did enter into in the past, being invalid is not some wild and crazy idea. And I'm pointing out why it's not just a long-term selling of your labor that's invalid. It should be any selling of your labor as an employment contract, renting of a person, is invalid for the same reason. It's not a matter of how long the duration of the contract. It's a contract that intrinsically puts a person in the position of a thing that can be rented, and people can't fulfill that role. So they never fulfill the contract. The law says as long as you don't commit a crime, we will count you obeying the employer as fulfilling the contract, and then the whole mechanism, well, the employer also paid all the other costs, and therefore the employer gets a product, kicks in, and the law never holds a trial to say, well, who in fact was responsible? Because the facts of responsibility don't change, whether it's a crime or not. I think everybody understands that, and nobody doubts that. Yet you get a totally different result because the contract is considered valid, is validated by the legal system. Says you obey the master, same in the old marriage contract, you obey the master, then you've done your share of that contract. But obeying the master isn't transferring labor. Obeying the master is being co-responsible together with your working employer for producing the whole product. And so if that contract's invalid, then capital can only be hired. I mean, you can only have labor hiring capital, which is so means, for example, in a firm organized on that basis, legally organized on that basis, there'll be no such thing as equity capital. That the equity function of being the residual claimant is attached to labor per se, and that's the end of it. And that's the same in any democratic municipality. As you know, there are municipal bonds, but there's no municipal equity. Bonds are debt capital, and we cannot sell the equity shares in a city or a township. And it's exactly the same thing. If a firm is organized as an industrial democracy or an economic democracy, there are no equity capital shares. The equity is attached to the role of working in the firm. So this idea of having no equity is familiar to anybody who stops to think about a city or a town.
Though ironically, that's the stuff that these libertarians are wanting to get rid of or something.
Yeah. So you should Google on charter cities and this whole movement now of libertarians that want to set up cities where the cities are basically owned by corporations, and anybody, citizens or workers or whoever comes there, agrees to this rule. And so you're back to the old idea that government, even when it's non-democratic, is based on consent. That's part of this whole intellectual history of autocracy. Is the liberals have tried to say that democracy is government based on consent, which is true, but that's not the characteristic feature. It's based on consent that does not give up your rights, that does not alienate your rights to self-government, whereas the old theory of autocracy was the sophisticated theory, was not divine right or patriarchy. It was that the people in any settled monarchy have, by the prescription of time, voluntarily transferred their right to govern themselves to the monarchy. And that was explicit, for example, in Hobbes, talked about explicit contract, and then in traditional theories of monarchy, that was an implicit contract that people have given up. So the charter cities idea is, okay, let's organize a municipality on this basis, that by moving there, and these are new cities, so you're not latching on to some existing population, you're building a new city, and I can, there's one plan to do it in Honduras, and there's another plan to do it in Georgia, not the state of Georgia, but the former Soviet Republic of Georgia.
Or on a boat.
Or on a boat, where it's even easier, because then you don't have a Supreme Court to declare it illegal like they did in Honduras. And, but that's a very real thing, and it's pushed by this fairly liberal, not even libertarian economist, Paul Romer. He used to be at Stanford, now he's at NYU. And so the idea there is that development depends on having this certain set of laws, like Hong Kong used to have, and Hong Kong traditionally was not a democracy. And so let's build these new Hong Kongs. People give up their right to govern themselves by voluntarily choosing to move there. Those are the terms. And then you're governed by the corporation or whoever it was that set up the city, and that's that. So the real question in the history of democracy was not government based on the consent of the governed or not, but is that consent to alienate your rights or consent to secure your rights? In other words, was it a democratic constitution that secures your rights, or was it a undemocratic constitution, like in effect the Constitution in a charter city, where you give up your rights if you agree to it, and you agree to it by voluntarily moving to that city, and you can leave any time. In the case of the boats, it's called seasteading, which is the takeoff on homesteading, and so you have these cities, sort of water worlds out there, and if you hook up your houseboat and plug in, then you agree to those terms, and that's fine. And if you ever disagree, you unplug and you motor over to some other floating city. And in this I just mentioned earlier this book review of Meltzer's book, and in the same issue of this is a right-wing journal that I occasionally read called Foundation for Economic Education. The lead article in the journal was called "Vote with Your Boat," referring exactly to this seasteading idea.
Gregor, do you have any questions?
Yeah, I'd like to cut in here. Can you hear me actually?
Yeah.
Yeah,
Fine.
great. Okay. Yeah, I have. I could make one attempt at what both a neoclassical theorist and/or maybe a labor theorist of value could at least be puzzled about, or try to respond to what you say. I mean, I think.
Actually, excuse me, Gregor. Before you start, the guy to your left, if you've got the same screen I've got, is also in the PhD program in economics at the New School. Just so you know.
All right. Well,
handsome guy.
Good to meet you in this way. Hi.
Right.
So I was wondering if all the factors of production, to use that language, including labor, were paid according to their marginal product, and that could somehow be figured out what the fair marginal product is, or if labor was paid, all its value that it has produced, if it was fairly paid for it. And that, of course, involves some money. If that money was transferred to these input factors, to these people who were producing, couldn't one argue and say, well, we made a contract. You rented out your labor, and but instead of being responsible for what you have created here, you take this money and you buy something else, and thereby you will be responsible for that instead, for that product that you buy with the money. So couldn't that?
No, people
yeah.
can perfectly well agree to give up their responsibility, and certainly the hired killers in that contract would certainly agree to that. They don't have any animus against the people they're killing, and so they will perfectly well agree to give up that responsibility. And yet, of course, they don't. They still have the de facto responsibility. So the agreeing to play the role of a non-responsible instrument, people can do that. They do it all the time. That's the old slavery contract, that's the old marriage contract, and that's the employment contract, are all contracts where you agree to play the legal role of a thing. And nobody, I mean, Marxists keep trying to argue that these contracts are involuntary, which is using a notion of involuntariness that has no, would apply to everything. Of course, people can agree to that. I'm saying they can, in fact, do it. Tell me how to transfer de facto responsibility, and you've got, you know, hundreds of thousands of hired criminals in jail that say, yeah, tell us how to do that. We thought we did
that. No, I mean, I'm of course not trying to defend the criminals, but you know, you were talking of legal acts, and
right, so
I'm just saying basically how to plasticize this responsibility. So suppose everybody is an owner of what they have produced, so in, let's say, in a cooperative, but then these people would like to acquire something else instead, some other product. So basically what you're saying is, if I understand you correctly, despite, let's say, exchanging these products that two people have produced and thereby have de facto responsibility about them, despite exchanging them, the de facto responsibilities
but they don't exchange
them.
They don't own them. This was the pie example. The Tony's friend who's producing the pie doesn't own the pie. He didn't pay for any of the inputs, the other inputs.
Right.
And so the legal system will not. So he's not selling pies. He's being paid a wage according to a piece rate. And when you analyze a piece rate worker by saying, you know, like they're owning what they produce in a piece rate is nonsense, because they don't pay for any of the other inputs. So how can they own the output?
Okay, well, I guess I gotta chew on that a little while before I can get back to you.
One example just came to my mind.
This is Matthew now, right?
Yeah, the media industry, right, would fit in pretty well here. I mean, there is rented capital to some extent in terms of like the high-powered computers and whatnot, but you know, there seems to be a fairly well understood division of profits and also like a share of responsibility to some extent, right?
Which industry are you talking about?
Well, I mean, the first thing is that it's sort of hard to find like any sort of labor contract or any sort of labor relationship that fits in well with the theory of property, right?
You mean labor theory of property?
Yeah, I mean, other than a small business owner doing stuff.
Yeah, well,
yeah.
I want to say he's working for himself, but I mean, whenever you have a employment contract, then by definition, the employees are simply an item of cost to the residual claimant. The residual claimant pays for labor and the other inputs and then gets the outputs. So the employees, all the employees are appropriating there is sort of their labor as a commodity, which they sell.
So I mean, so in a scenario where there are royalties, that does fit, right? That fairly well. I mean, that almost works to some extent.
Well, you have. Are you talking about, well, patents, and I mean these are.
I mean, these are media royalties. Like, for instance, the actor who speaks more than 3 lines has some division of the profits. You know, for any sort of.
Yeah, no, but that's not a. They're not. That's a. That's something like a piece rate. That's not the actor is not an independent production, being the residual claimant. They're totally hired for the job. But when you're hired, you can be the wage rate can be determined in a number of ways, and sometimes it's a straight flat rate for time. Sometimes it's a piece rate, and sometimes it can be like the value of what you sell, where it's over time, and you get a share of that. But it's still your wage. It's simply how your wage is calculated.
If I could.
It's the same way, by the way, and I used the example before of the owner of the corporation that owns a mall leases out the space to the stores in the mall. So the owner of the mall is not a residual claimant in the operating of any of those stores, but the lease payment is sometimes geared to the actual amount of business in the store. So it's not that there's some legal partnership. It's that the amount of the lease, there's a base lease, and then there's amount of lease according to the amount of business that comes in the store. So that tends to coalesce the interest of the guy running the store, the residual claimant in the store operation, and the mall owner to maximize the the foot traffic into the store and the revenue in the store, because their lease payment will go up.
The process of production is, what is that what I mean to say is that's what you were calling the firm, right? To some extent?
Well, part of the way the issue is framed is the word firm gets tossed all over the place. So when you're talking to somebody about this, you've got to be very clear what you mean by the firm. A lot of people say there's the ownership of the firm. They just mean the ownership of a corporation. And there certainly is the ownership of corporations, but corporations are not necessarily residual claimants. They're not necessarily the operating party, like the owner of the mall is not the operating party in the stores in the mall, because they lease the space to the operators. We're going to take another example. One I use in the book is when you go to a gas station, say it's a mobile gas station, who's operating the gas station? Well, it could be a corporate station where the people working in the station are employees, or it could be a locally operated station where you have an independent operator who's leasing the space from mobile corporation. Either way, and so, or even in when you go to a McDonald's franchise, is it a corporate franchise or is it an independent franchise? If it's a corporate franchise, I mean, it's not a franchise at all. It's a corporate store, so it's run by McDonald's, or it's a individual franchise which is run by the franchisee. Now, I quote an example in the book, which is it goes back to the gas shortage. I think it was back in the 80s, and there were a lot of gas companies that had leased out their gas stations to independent operators. So you had these local guys who were operating the gas station, and they themselves may have had employees, but we're looking at the relationship between the operator of the gas station and the oil company. And then there was this oil crisis, and due to this war in the Middle East, and the gas prices shot up. And so to allow the independent operator to continue to operate the gas station at the old long-term lease they had, left the oil companies out of a lot of the profit. So what they did was that they terminated the leases and said, okay, we will hire you as an employee, that this is basically what your net income was before, and we're now going to we'll pay you that as a corporate employee, but now we are going to so now capital is hiring labor rather than labor hiring capital. And there were some cases where people who had operated the gas stations barricaded themselves inside with shotguns and said, no, I own the firm. So they had this whole myth that they own the firm, and you got to pay me for the firm, and that you got to pay me for all the future profits that I would have made. And the oil companies said perfectly correctly, no, we leased you the assets, and we're now not going to lease it to you anymore, but we'll offer to hire you. We want to, in other words, reverse the contract. Of where who was the operator really depended on which way the rental contract was made. Was the independent operator leasing the facilities from the oil company, or was the oil company renting the operator?
Okay, one other thing that's probably worth reviewing, in part for Gregor's input, or because he's new to these conversations, is this. Unless Matthew, do you have a comeback with that you want to do?
No, that's all right.
Okay.
Also, by the way, just quickly, I think I do get you, David. So I think I do understand. I think my question was the following, if I can still ask that, and then maybe you can go, Chris.
Sure.
You can go ahead. I think my question was the following. So suppose people did not rent out their labor, but in fact there were actually only, we consider a situation where there are only producers that produce their own products, and they're de facto and legally responsible for them. And suppose those two then entered into an exchange. So we do have the conditions that the labor theory of property would advocate, okay? And then there's an exchange taking place. I was just wondering who then has the responsibility, the responsibility for these products after they have been exchanged. Do they still lie with the producers, or can they?
No, responsibility is we're talking about the initiation and termination of property rights. I mean, that's, if you look at the life cycle of a property right, like any life cycle, it's born, transferred, and dies. Okay. So the dying of a property right is what happens when you consume something in production, or you consume it as a consumer. Then you have this imputation of the liabilities, and it's usually to the last person, unless you have a tort being committed. When I consume somebody else's property and they didn't consent to it, then they're going to sue me for damages. And what's that about? Well, that's saying that I was de facto responsible for using up or destroying that property, but they were the legal owners. Therefore, I should appropriate the legal liability, which means I got to pay them. That's what a tort's all about. A damage suit for property that's destroyed. Exactly the same principle, and we're just applying that principle across the board, where there's no tort and no crime. It's exactly the same principle to ordinary production.
Right. That makes sense. Good. Thank you.
And just to give you another example, people like to try to interpret the employment relationship as if the worker is selling the product, and so I pointed out that you've got to own something before you can sell it, and since the worker doesn't pay for any of the inputs that go into it, they have no property right to the output to sell. But where you do have a property right to the output, you can sell it ahead of time. That's no problem. I mean, the farmers do that all the time. You have an independent family farmer, they pay for all the inputs, they own the crop that's going to be produced, but they may sell the crop ahead of time on a futures market to lock in a certain price. Perfectly all right. But they have to fulfill the contract either with product they produced, corn that they produced, or if they have a bad year, they got to go buy it off some other market and fulfill the contract. So there's no problem with selling your product, but you got to own it before you can sell it. And to own it, you means the legal responsibility, and that means you got to be the one that also bears those costs.
Yeah,
thank you. That is helpful. So please go ahead, Chris. Now.
Yeah. Okay. Well, I was just gonna review the voluntary involuntary dimension of this. The libertarian and the man or woman on the street listening to David Ellerman, doesn't have to be a formal libertarian, says this is a bunch of hogwash, because if people are voluntarily agreeing to this employment contract, so they're not exploited, they're not right. They're not, their humanity isn't being robbed from them or whatever, and to which the Marxist will say, I'm obviously caricaturing this, well, you're you're allowing yourself to be made use of like a tool, and as long as there's a dime, a penny of value being made and retained as profits and not going out as income, then you are in fact being exploited in this kind of narrow economistic way, which theoretically is eliminated if labor power, collective solidarity, whatever, is so strong that they can wring every last penny out of the production process and leave the capitalist with not a penny to reinvest and the like. That's not the Marxists' problem. They've eliminated the exploitative condition by extracting all of the capital. And so that's how the Marxist responds to the witless citizen who says, I'm not exploited. They say, yes, you are, and that's why you're not. Dave Ellerman says, you witless human, you witless Marxist, you're not getting at the heart of what the exploitative relationship is, because it's these responsibility relationships. It's the servility, that is implicit and explicit, if you look at how the employment contract is written, that gives labor no effective governance, no positive governance power, and no responsibility for the success of the common enterprise, and no sharing of the fruits of the labor. Is that a fair summary, David? I mean, at kind of 15,000 feet of the three positions, the whatever, the libertarian, the ordinary citizen, the Marxist, and the Ellermanian?
Yeah. Well, the libertarian puts all the emphasis on the voluntariness, and that sort of settles it. And that was sort of what I went into with Tony's example of the pie making thing. That both, I'm not saying that the guy who ends up making the pie doesn't agree to it. He could agree to the whole deal. I mean, no problem. But the deal, and just the way, the same way a hired criminal can agree to the whole deal, that he will certainly transfer his responsibility to the employer, no problem. But the facts are not that. The facts are that he remains a responsible person in both cases, and so you get a mismatch between the de facto responsibility and the legal responsibility, and that is what is traditionally called an injustice, is a miscarriage of justice, a mismatch between the two. The Marxist theory has several levels. I mean, it's another one of these sort of lawyers' list of, if you don't believe this argument, how about this argument? And so at one level, the Marxist says, well, it's actually involuntary. It's sociologically involuntary, because once the commons was enclosed,
Right.
say in England, the thing that Karl Polanyi wrote about so much, then people were left without access to the means of production, and therefore they had to sell their labor. So the selling of their labor is a involuntary act. And of course, by that criteria of involuntariness, almost everything we do, every market transaction, when I go to the supermarket and spend $60 on food, I would prefer to get the food and not pay for it. And so if I had been born with a farm or born with a supermarket or whatever it is, I wouldn't have to do that. Yet I do. So therefore, it's an involuntary transaction. I would much prefer to get the food without paying for it. So that notion of involuntariness may allow one to strike a Marxist posture, but it's really not a juridically usable concept. And in fact, the contracts we make as consumers are less voluntary, if you wish, than the labor contract. Labor contracts, at least in the distant past, were collectively bargained, and so you actually had something to say about it. Whereas the consumer contracts are almost always contracts of adhesion. Take it or leave it. You don't go to the cash register in the supermarket and negotiate the price. So, so to try to say that the labor contract is involuntary, but the contract the supermarket is voluntary is doesn't quite pan out.
Okay,
And,
but could you back up a little bit about I'm curious about this your differences with the Polanyi stuff, and the people coming off of these the commons were forced to sell their labor.
well, I mean, it goes back to the whole notion of course, bargaining power. When the labor contract is permitted, then bargaining power will come into it, and the bargaining power depends on whether you have independent income or independent access to means production. And so to supply the new factories with labor, you did need to deny people the access to the peasant lifestyle, and that's the way capitalism was built. There's no doubt about that, and we also see that incidentally going in reverse in the a lot of the post-socialist republics, where industry was destroyed by the collapse of the Soviet Union and the collapse of socialism. Then a lot of people went back to the countryside. They went to their their cousin's farm, and that's how they got their food. So they where they had access to the land. So all those things matter in the whole question of bargaining, and whether you have access to meat production, whether you have access to finance, the question that Mike has looked at. These are all important questions, but they're the point I'm making is not a point that depends on a weak bargaining position. It goes into the nature of the contract itself. And I mean, suppose you had a voluntary system of slavery. I mean, once the one class gets monopoly ownership on land, they're in a pretty good bargaining position.
Okay, so wait a minute. So you're to summarize, because it is that's this really rich and important thing to understand in terms of history.
Right.
Is that the peasants coming off the commons were, in your way of looking at it, merely in a weak bargaining position?
Yes.
Right.
That's the. I mean, they didn't have access in any easy way to pasture for their sheep or their cattle or something like that. They could have lived off small gardens and all that, but this has happened again and again in history. Is some major change. I mean, look at the breakup of feudalism. Once again, the sophisticated interpretation of feudalism was based on a voluntary contract, a contract between the serf and the lord, that the lord would supply protection and usual food, clothing, shelter, and the serf would supply the labor to work the manor and so forth. And by the way, it's very, even the etymology of the words is very interesting, because the Latin word for slave is servus, and it is the root of both serf and servant. So you have the sort of three major forms of labor: slavery, serf, and servants. All have the same etymological root. But in the Middle Ages, serfs were higher status than slaves, and because the serfs were part of the real estate, and the real estate wasn't for sale, so they had this sort of tenure, whereas the slave could be sold individually, and so the slave was much lower status. So you needed a retronym to name the slaves, rather than calling them servus or servi. And at that point in Europe, the slaves were Slavs, and so if you go to all the different European languages or Romance languages and look for the word for slaves, you'll see it's the same word for Slavs. It's not just English; it's also true in other languages. So anyway, let me finish this point. So how did that system break down? How did serfdom break down? And one of the major factors in the Middle Ages was the Black Death. So the Black Death was a great boon to the survivors, because they were now a very valued commodity, and so they could leave the leave the manor and be hired as employees, which is a higher status still than the serf. And the new employer would not report them because labor was so scarce due to the Black Death. And so that is one of the major contributing factors to corrupt the whole system of bonded labor, where people were bonded to these feudal manors. And that greatly increased their bargaining power. And so you had this, in the Elizabethan period, you had a law actually passed that people couldn't bargain for their wages, this law statute of artificers and vagrants, because the people that were the masterless men, the serfs that had left the manor, were called vagrants, or masterless men. And so all the wages were then set by law and by this statute of artificers and vagrants. So anyway, the enclosure movement was another major factor in that reduced the bargaining power of workers, just as the Black Death had increased the bargaining power of workers. And each of them, affected the transition from one type of dehumanized labor to another.
Okay, just a quick question here. I've just finished reading this self-rule book of Weeby's. Is that how you pronounce this guy's name? Weeby?
Something like that, yeah.
Weeb or something. He's got on this kind of point. He's talking about 19th century United States history, and the changes that were going on. He says, nevertheless, stubborn masters managed to preserve some form of the master-servant relationship until a legal ruling in 1821 abruptly pulled out its central prop, the court refused to enforce such a contract against the will of an adult. If the servant could simply walk away, who was master? As courts elsewhere made the same judgments, the system crumbled. By the end of the 1820s, even immigrants, no favorites at law, could escape indentures.
That was indentured servant.
Yeah, indentured, right. Which is where does that fit on this typology?
You had the difference between the normal employee and the slave, the voluntary slave, is simply the difference in the tenure, the time period of the contract.
Right.
And indentured servitude is somewhere in between. That's where you have a long-term contract, and in return, say for your passage to America from Europe, you need to sign on for 7 years or whatever it was, and so you were not in a position to walk away and without redeeming the remaining, as it were, 6 years of your contract or something somehow to your employer. And once the courts no longer enforced those sorts of contracts, then that whole system of indenture broke down.
Right.
And so you had this, what's the expression, at liberty employment?
At will
employment.
Yeah, that's right.
And
you wouldn't happen to know what this 1821 court case is, do you?
No, I don't know.
Okay. All right. Sorry.
But that, by the way, is the when you argue with libertarians, as I sometime against my better judgment do, about the slavery contract, they say, oh no, we're against the slavery contract, we object to it, it's inherently bogus and blah blah blah. So then say, okay, would you explain how this violates libertarian principles? And as they explain it, it is that it's a contract where one party, you sell yourself into slavery, so you get this one-time payment from the owner, which you could distribute to your relatives or do put it in a bank or whatever you wanted. That's not part of the question. And then you have this obligation to supply labor to your owner or to your master for whatever the time period is, the rest of your working lifetime. And the question arises then, well, what about, so it's one of these contracts where one party performs up front and the other party performs over a period of time, like a mortgage. So when you take out a mortgage from a bank, the bank gives you the money all at once, and then you have to pay it back over a period of time. So you've got this, once again, it's not a direct quid pro quo on the market where I give you this, you give me that. There's this time differential. And the whole question is, in each case, is suppose the person that has to perform overtime changes their mind, wants to get out of it.
Right.
What do you do? And so the libertarians' argument against the voluntary slavery contract is that if the response of the owners is then the fugitive slave laws to go grab the people and force them back, that's a violation of libertarian principles. So that's what they object to. They don't object to the slavery. They object to the physical enforcement of the draconian fugitive slave laws against slaves that change their mind in this contract in mid passage. And so I say, okay, so let me give you a different version of the voluntary slavery contract. Suppose that when the master pays you this upfront sum, that's put into escrow. And then you have the escrow will release proportional parts of that. So say you have 30 years left on your working lifetime before you retire. Then as you perform that labor over the 30-year period, then proportionate amounts of the escrow account will be released to you, and they could even accrue interest in the bank. And you do with them what you wish. They could go to your family or relatives or your children or whatever purpose you had in selling yourself into slavery. Then there's no problem, because if you terminate the contract, then they simply terminate releasing the escrow to you, and that then reverts back to the slave owner. And libertarians have no objection anymore, because all they objected to was the non-libertarian draconian fugitive slave laws when the slave chooses to breach. So, which is hardly a per se objection, even though they make great flourish of saying this is against our principles and blah, blah, blah. That's all that's against the principles, not any problem with selling yourself. It's selling yourself without a way that you can terminate the contract in mid-course and have one party of the contract have no recourse other than physical coercion. And but with the escrow account, you have no recourse. And you also see it's basically a long-term labor contract, a long-term employment contract where your wages are being released as you go along. Now, the same thing is with the mortgage contract. What makes the mortgage contract work? Suppose that people could walk away from a mortgage contract and would stop paying their mortgage payments but keep the house. Well, it wouldn't work. I mean, obviously, people would take out mortgages and then stop their payments on the mortgage and keep the house. So that's why you needed some way in which, for that contract to work, for the party that paid up front to have recourse, to be able to take foreclose on the house. And that's the only way the mortgage markets will work, is where the party that paid up front has recourse if the other party terminates their performance over the period of time. And so that's the sort of libertarian objection to the slavery contracts. Not a per se objection at all. It's just simply that we should have a set of institutions so that the slave owner has recourse.
Yeah, it occurs to me, Dave, because part of what is really, really hard for people to get their heads around about this argument is that it seems so counterintuitive or whatever, that we're talking about the existence of slavery like ways of describing a contemporary work is it all related to slavery, and that there's like two choices, this kind of witless agreeing to slave-like conditions, or breaking the chains and going to work for yourself, or collective self-employment through work ownership. But those are the only two ways of doing it. It's just sort of occurring to me here that it's kind of a rhetorical trick, I suppose, but some way of having a kind of a finer evolutionary, or finer differentiation of the so-called progress of human relationships, where you go from slave to serf to indentured servant to employee to collective self-employment or something.
Yeah, well, that's certainly true. That is the sort of progress that's
Right.
been made, and
Well, but that would kind of, by giving people some resting places between slave and collective self-employment.
yeah.
You
Well,
know,
but the slave analogy is not with involuntary slavery; it's with voluntary slavery, which is also outlawed. And so the big difficult intellectual point here is how can a voluntary contract be wrong? And which Marxists never explain, because they say, well, it's really involuntary, that we're really forced, and libertarians correctly say that the labor contract is voluntary, like the old marriage contract was certainly voluntary, and so forth.
Well, wait a minute. Are you calling the contemporary employment relationship voluntary slavery?
No, I'm calling it a voluntary contract. It's rental.
It's a rental.
I mean, some people use the phrase wage slavery, which I think is, is one way in which you could say that's correct, because it's temporary, part-time slavery, if you wish. But that's making an argument by using a hyperbola, which I don't think is a good idea. You should be able to make the argument using ordinary language, and not use that hyperbola. But the point is that there are a number of voluntary contracts that are already outlawed, and libertarians have no account for that. They have no account for why is the coverture marriage contract outlawed? Why are all marriage contracts now? And of course, we're talking about the advanced countries. The coverture marriage contract is still in force in Saudi Arabia, and a lot of the countries around the world.
I'm sorry. So your terms for the employer-employee relationship is voluntary employment contract?
Yeah, I mean, you're renting yourself out, and that's
right.
And that's even, as you know, that's the language in the textbooks. Is you're renting, hiring, renting. We say rent a car here, but in England they say hire a car, and renting and hiring is the same thing. You're buying the service. You're not buying the thing. You're buying the services, the thing for a certain time period. And when you rent a car, let's say you might have a charge by the day without a mileage charge, or so you'd pay the same cost whether you drive it one place and park it for the whole day and then drive it back, or whether you run around all day long putting a lot of mileage on it, because you're just paying for the time. And the Marxist theory is that you pay for the labor power, but then you work the hell out of the worker, you drive the hell out of the worker, as it were, and get more value out of the worker than you paid for. And that's the sort of theory of exploitation. So which you could apply as well to a rental contract. If you rented a car by the day and then you drove the hell out of it all over the place, then in some sense that would be called Marx could make the same argument that was exploitation. It has nothing to do with human labor versus, it's the same sort of thing. If you rewrite the contract to include mileage, then of course that's a better specification of the contract and the real cost borne by the car rental company. And you do the same thing on the labor contract. If you measure the labor well, then the idea that you pay for one thing and you extract something else would go away.
Any other comments?
We've gone over 2 hours, and I don't even know if YouTube allows 2 hours.
Yeah, it'll do it. Let me see. So for worker cooperatives, if you have a shirking worker, and I mean ultimately there is such a thing. I mean the corporation is liable for whatever harm is caused by the shirking worker, right? Because I mean, like it's never going to be the worker who is liable for lack of work, to some extent.
No.
Like for instance, you can say a doctor or somebody who has control over a life is ultimately liable for loss of life if they know that their action is going to cause a loss of life, if the process employed is going to result in a loss of life. But
the way to formulate this question is what happens when an employee commits a tort against a third party? So the doctor is negligent vis-a-vis a patient, and the patient dies. Something like that.
So
Is the worker responsible?
Well, the doctor stuff, I feel it was a mistake going in that direction because it overly complicates some certain
Right.
things. But in a worker relationship, right?
So
In
say a FedEx driver runs over somebody.
okay,
Who's responsible?
yeah,
Is it the driver or is it the company? Now, this is it was a big issue in early 20th century law, and the answer in the law is that they're both liable, what's called jointly, no, severally, which joint and several responsibility, which means you can sue either one, but you can't collect from both. So if you sue the worker and fail, or sue the company and fail, you can sue the other party. So in that sense, you can sue either one, so it's joint legal responsibility, but it's several in the sense you can't collect from both.
well, I mean, it's a question of. I mean, in this case, it's a question of process, right?
No, it's
So,
the
like
whole
FedEx
point.
employs a process where, let's say, a worker is knowingly overworked and he's tired, and therefore causes an accident. In that case, I'd say that's a joint liability type of situation, right? The worker knowingly got into like a car and decided to operate it while
Right.
while tired, and at the same time, FedEx knowingly put him in a car, knowing that he should have been tired, given that he had just worked 14 hours or something,
Yeah.
right? But in
But
other scenarios, like
but
for instance, let's say the truck is designed in such a way that he couldn't have seen a certain like person that he hit, no matter what.
yeah.
In that case, the liability would lie
No, but
with FedEx only, right?
you're stacking too much
Because
into
their
the
process. Okay.
you're stacking too much into the question. The thing is, just suppose it's some sort of normal negligence, and so if I, as an independent person, uh, hit a pedestrian in some situation where if I were more attentive or whatever, then the pedestrian would be able to sue me. And now the point of all this is as this situation has evolved, all this is taken care of by insurance now, so that the liability, that's what's called liability insurance, and companies have the same thing. That when their employees go out and run over somebody, they have liability insurance, and they cover that. But so we're talking about the real legal debate was before everything got sort of brushed under the rug of insurance in the later 20th century, in the early 20th century. And the interesting thing was that the judges said, well, by the natural rule of responsibility, the employee is liable. That the employee was a responsible human being and was negligent and da da da, and we're not saying did it intentionally, but he was negligent, which means you weren't deliberately not paying attention, not taking proper precautions, the definition of negligence. But then they said, well, but you should also be allowed to sue the employer. And then they said, well, why should you sue the employer? Because the employer had nothing to do with it. You see, that it was the worker that did this. So suddenly, again, the worker, in this is the civil case, not the criminal case. The civil case, the worker once again jumps into becoming a responsible human being, and the courts recognize that. So then you had this whole doctrine called respondeat superior in Latin, which meant let the superior respond. And the justification for it was not that the employer had any responsibility, but that they had deeper pockets, and that the purpose of the legal system is always to have a remedy available for innocent parties. And a pedestrian that got run over innocently, that was not at fault, didn't jump in front of the car or something, there should be a legal remedy. And if they only had the ability to sue the employee, that would not be a satisfactory legal remedy. By the doctrine of deeper pockets, they should also be allowed to sue the employer, who presumably has the deeper pockets, and that was the basis for the doctrine of respondeat superior. And they even had a name for the liability of the employer. It was called strict liability. And the word strict meant, well, they're not actually responsible, but we, in law, say they're responsible for these other reasons, deeper pockets, and therefore it's called strict liability as opposed to sort of actual liability, that the actual liability rests with the negligent employee. This is all in the book, by the way. It's all buried in later chapters. and so that was once again, it's not as a little more complicated than the hard criminal case, but once again, it's an example of where when the law looks as to who is actually responsible, then they find the employee is responsible, and the employer, any liability that the employer ends up appropriating is a strict liability, not a. So you're breaching the principle of responsibility by saying we're going to hold the employer liable even though he's not actually reliable. It's a strict liability. It's one done for social reasons because he has the deeper pockets, and that's and of course if we do that, then that'll employers will also then better supervise their employees and not let them drive drunk or when they're half asleep and so forth.
I mean, what I meant was, in those type of scenarios, it's sort of easily, you could talk about it for a while, right? Or you can leave it up to the courts to some extent, right? Or as in, like, there's a natural course of action to in some way or another. But when it comes to just like a worker shirking or somebody who's supposed to produce widgets not producing widgets.
Right. Well, let me give you. There's a famous example of a delivery person that had a certain route they were supposed to cover, and they went off the route to visit their girlfriend, and then they ran over somebody coming back from visiting the girlfriend, and so it wasn't even on their normal route. And then the employer said, well, no, we should not be liable for this because this was a frolic and detour. And so the phrase frolic and detour became a legal phrase to say that you weren't doing what the employer expected you to do, and therefore you yourself took this out of the employment situation in your frolic and detour. And so in that case, respondeat superior does not apply. So that's
sure, but the liability for the missed package, that lays with the firm.
I don't know.
Like, let's say if there was a package undelivered, right?
Yeah.
The deliverable product not delivered, it has to always, it has to lie with the corporation, right? It has to lie with whoever owns the contract for delivery.
Yeah, well, that's one of those questions of where does the actual change of hands take place.
And so in a worker cooperative, let's say even with 5 or 6 people, you're never going to be able to assign liability to the individual that shirked.
If it's just shirking, maybe not. But there's certainly you have exactly the same problem in a cooperative where an individual commits a tort, and the question is the individual suable or is the cooperative suable? And seems to me pretty much the same thing holds, and that's why companies have liability insurance.
Yeah, I don't know. I don't know where you're going with this, with the famous economist's preoccupation with shirking. It is a familiar refrain, and it's mind-boggling that the economics profession somehow thinks that worker ownership is going to lead to increased shirking,
right,
as opposed to the conventional capitalist employment relationship where you've got professional managers with ever increasing levels of technology and sophistication, and protecting against shirking. Which is why it must be such a superior system to worker ownership. That's what you've been taught in graduate school, right, Matthew?
That's the
monitoring and shirking, sure.
Yeah.
Actually, I don't think I've ever heard of shirking in a neoclassical sense. Yeah.
Gregor, you have anything to add here?
Well, no, I think I have come across shirking. And basically you try to ensure that there's no shirking by how's it called? By constructing some mechanisms, by designing mechanisms.
Right.
Of course, then you have to make certain assumptions about how humans operate in order to define these mechanisms. But so yeah, I did come across that. I haven't come across the argument that there's less or more shirking in worker ownership, but that's probably
that's part of the argument part of the argument for piece rates is it defeats one type of shirking.
Mm-hmm.
Of course, it encourages another type of shirking on quality.
Right.
Right.
Let me terminate the broadcast. We can keep on talking, but I think we're straining our listeners. It's 2 hours.
It's fairly easy to edit this thing.
Okay.
So you'll be able to
I'm going to
mix out whole sections if you want.
I'll terminate now.